Over at the Drudge Report, Drudge has a link to a piece in Politico, which is absolutely fascinating. It's from late last night, and I meant to get to this. Only so much time. Listen to this, and I'll tell you what I think's going on. Mueller, remember him? Mueller link seen in mystery grand jury appeal. The special counsel appears to be locked in a dispute with a mystery grand jury witness, but much of the case is sealed. Special counsel Robert Mueller appears to be locked in a dispute with a mystery grand jury witness, resisting giving up information sought in the ongoing probe into alleged Trump campaign collusion with Russia. It's unclear exactly what the two sides are fighting over, but the case appears to resemble a separate legal battle involving an associate of Trump ally Roger Stone, Andrew Mueller, who's fighting a Mueller subpoena. Mueller's lawyers are using the case slated to be argued at the D.C. Court of Appeals early next month, excuse me, to mount a broad legal assault on Mueller's authority as special counsel. Now, I don't know how this is going to turn out, but you'll recall on this program, this is something I've been urging, challenging the constitutionality of this appointment. Let the chips fall where they may, but it needs to be challenged. And apparently that's what's taking place. In the more shadowy case, which involves an unknown person summoned before a grand jury this summer, the D.C. Circuit on Monday set a separate round of arguments for December 14. The case traveled in recent months from U.S. District Court Chief Judge Beryl Howell to the U.S. Court of Appeals for the D.C. Circuit, back down to Howell and back up again to the Appeals Court, with most details shrouded in secrecy. Another indication that much of Mueller's activity is taking place behind the scenes and is rarely glimpsed by the press or public. So this battle's going on in the grand jury. And there are appeals, obviously, taking place up to the circuit court, which is right under the Supreme Court, over whether or not, I suspect, broadly speaking, Mueller has the authority to do anything that he's doing. However, a Politico reporter who visited the appeals court clerk's office on a day when a key filing in a dispute was due earlier this month observed a man request a copy of the special counsel's latest sealed filing so that the man's law firm could craft its response. The individual who was asked for the secret filing declined to identify himself or his client and replied, "I'm okay," when offered a reporter's business card to remain in touch. 3 hours later, a sealed response in the grand jury dispute was submitted to the D.C. Circuit. Another detail emerged Wednesday, strengthening the secret legal battle's apparent tie to Mueller's probe. The first appeal appears to have been rejected by a D.C. Circuit panel as premature. The witnesses' lawyers asked the full bench of appeals court to review that decision, but a notation in court filing says only 9 of the court's 10 active judges participated. Bowing out was Judge Greg Katsas, the court's only member appointed by President Donald Trump. Katsas served as deputy White House counsel before Trump tapped him for the powerful D.C. Court of Appeals last year. Goes on. A spokesman for Mueller's office, Peter Carr, declined to comment on the litigation. Lawyers for Trump said the mystery grand jury subpoena fight moving through the D.C. Circuit had nothing to do with the president. No idea, said Trump personal attorney Jay Sekulow when shown the docket for the case. Attorneys for Roger Stone said they didn't know of anyone challenging a Mueller subpoena beyond Mueller. Mueller's lawyers agreed with Mueller's prosecutors to make many aspects of the dispute public. No such agreement appears to have been struck in the other fight, although Mueller's team and the mystery witness did file a joint motion earlier this month asking the appeals court to expedite resolution of the dispute. Several other lawyers who represent witnesses in the Mueller investigation also said they were unaware of who's crossing legal swords with the special counsel's team in the largely secret case. A few bare-bones details about the dispute are available in the public record. While all records about the litigation in the district court are sealed, the D.C. Circuit's docket shows that the case was brought in the D.C. court on August 16, and Howell ruled on it September 19. The initial appeal was filed 5 days later. Stay with me on this, because we'll try to make sense of this. It's actually very, very fascinating. The bottom line is, Most likely scenario is someone filed a motion to quash or otherwise resisted a grand jury subpoena, and the judge issued an order denying that and saying the witness needs to testify, said Ted Boutros, who I know, a Gibson, Dunn, and Crutcher attorney who has handled grand jury-related litigation for journalists and media organizations. It's unclear whether the case the appeals court has agreed to hear in December involves an assertion of attorney-client privilege or some other privilege, is framed as a broader attack on Mueller's authority, or perhaps advances both sets of arguments. It's very hard to tell from this docket. Well, I'll tell you, it's not hard to tell at all. Mr. Mueller challenged, we know from a few months back, the constitutionality of the appointment of Mueller under the Appointments Clause of the Constitution, the same argument I've been making and Professor Calabrese has made. I don't know exactly what kind of argument they're making. Obviously, I'm not privy to this sort of thing. But it's the same person, Mueller, and I assume it's the same lawyers who are making this argument. Probably challenging the subpoenas by challenging the constitutionality of Mueller and his operation in the first instance. I suspect, I believe strongly, that that's what's taking place. Again, not because I have first-hand knowledge, but because, remember what took place a few months ago. The grand jury cases pose a threat to Mueller's investigation because they can serve as vehicles to get questions of his authority and legal legitimacy before appellate judges relatively quickly, and I believe that's what's taking place here. Such questions have also been raised by defendants in some of Mueller's criminal cases. But all the human defendants who've set foot in a courtroom have ultimately decided to plead guilty and drop any challenges to the special counsel's authority or tactics. Mystery cases moving through the courts involving grand jury matters and independent counsel matters aren't uncommon. A 1997 conflict of interest investigation into AmeriCorps Chief Eli Siegel's fundraising activities was conducted under seal from its start. And a final report remains out of public view involving another Clinton-era probe, the Labor Secretary Alexis Herman, and influence peddling accusations. This can get a step or two weirder than it already is, said an attorney representing a senior Trump staffer in the Russian inquiry. The lawyer recalled a case from a previous investigation where he couldn't even get to see a judge's opinion because it was under seal. All right. I'm fairly confident that this is the case that was originally brought involving Mueller by counsel. As I said, they questioned the appointment of Mueller under the Appointments Clause. Now, the D.C. Circuit has been packed with leftists and Obama appointees, so who knows what will happen there. Perhaps they're building the foundation also to take it to the United States Supreme Court. And despite what you've heard by a senior judicial analyst and others, this is not the Morrison versus Olson case of 30 years ago involving the independent counsel. The elements in that court decision appear to have been violated, in my opinion, and in Professor Calabrese's opinion, respecting Mueller. And this is why these two questions are important. Stay with me because you're smart, and you'll be able to follow all this. We've talked about it before. Is Mr. Mueller a principal officer of the federal government, or is he an inferior officer? For purposes of a challenge to the Appointments Clause of the Constitution, I have no doubt that he insists that he's an inferior officer who reports to Deputy Attorney General Rosenstein, that he did not have to be nominated by the President and confirmed by the Senate. He's nothing more than an inferior office official, like some assistant United States attorney or deputy to an assistant attorney general. Now, you know that's not true. He's got more power than a U.S. attorney. And the reason, among other reasons, that he has more power than a U.S. attorney is because his initial appointment was enormously broad and didn't provide any criminal basis for his investigation. We've talked about that. So this isn't like Morrison versus Olson. Now, the court may conclude that it is, but on the facts it is not. It's a legitimate challenge of his authority. I don't know where it'll go, but I'm glad it's being done. And I more than suspect. I believe strongly that that's the ping pong that's going on between the trial court, the district court, and the appellate court back and forth. And that's why the appellate court is going to hear the case. And again, as I said, that court is heavily loaded with leftist activists. So the final case will have to be made to the Supreme Court if they'll accept it. We'll be right back.